that the Supreme Court does not have any jurisdiction, or it is a political question. They cannot issue TROs or orders that will, in one way or the other, affect how we try and how we decide this case. Thank you, Mr. President.
Thank you. Majority Floor Leader.
Senator Pia Cayetano, Mr. President.
The distinguished lady senator from Taguig.
Mr. President, if I had my choice, I would not have wanted this to come to a vote. In the trial last week, I had hoped that one of the witnesses would, on his own, after contemplating and thinking of the repercussions of his refusal to provide the information on the foreign deposit, would come here voluntarily to disclose the same. But given that the decision of the majority was to bring this to a vote, I chose to cast my vote in favor of defying the TRO. Mr. President, I base my decision on the following. I think it is very clear to all of us that we are very young in terms of our jurisprudence when it comes to impeachment. We really have no firm cases to base our decisions upon. What we have is a constitutional provision that states that the Senate is the body that is charged to try all cases of impeachment. So we look to the U.S. as we do in many similar cases, and there is a U.S. Supreme Court, Nixon versus United States. In this case, Mr. President, a United States federal judge was convicted of federal crimes and was sentenced to prison. After that, the House of Representatives adopted impeachment articles of impeachment and proceeded with the impeachment. He was impeached and the case was presented to the Senate. Judge Nixon then questioned the Senate proceedings. It then went to the Supreme Court and the Supreme Court ruled. The Supreme Court ruled that there are reasons why the judiciary has no role in impeachment. The Supreme Court stated that the framers of the Constitution recognized that there would possibly be two sets of proceeding. One would be a criminal trial, which in this case the judge faced, and an impeachment trial. And therefore, the criminal trial already called for judicial interference, in fact, judicial supremacy. But the impeachment trial called for the impeachment court to be the sole judge. The respondent, Judge Nixon, argued that judicial review is necessary in order to place check and balances on the legislature. He feared that the Senate, if the Senate is given unreviewable authority to interpret the impeachment trial clause, there would be a grave risk that the Senate will usurp judicial power. On this matter, the Supreme Court ruled the framers of the Constitution anticipated this objection and created two constitutional safeguards to keep the Senate in check. The first safeguard is that the whole of the impeachment power is divided between the two legislative bodies, with the House given the right to accuse and the Senate given the right to judge. This split of authority avoids the inconvenience of making the same person both accuser and judge, and guards against the danger of persecution from the prevalency of a factious spirit in either of those branches. The second safeguard is the 2/3 supermajority vote requirement, and that is the same requirement that we have under our Philippine Constitution. Finally, Mr. President, I'd just like to mention that there are lengthy discussions, and I have taken the time to read the Federal Impeachment Process, a Constitutional and Historical Analysis by Michael Gerhard, wherein it states, judicial review of such an impeachment procedure would undermine the impeachment's effectiveness as a check on executive and especially judicial abuse of power. Judicial review of the impeachment process would give judges the last word on the propriety of the procedure for their own removal, and thus the chance to make their own or their colleagues' removal virtually impossible by ensuring that Congress could achieve such outcomes only through the most complex and time-consuming ways. I have many more interesting points that I can put on record, but I think I have covered the most important ones, and I thank the Senate President for the time to put on record my sentiments on the matter. Thank you.
The
Yes,
chair,
Mr. President, Senator.
the chair would like to make a statement apropos to the statement of the lady Senator from Taguig. I agree with what you stated, Madam Senator, but I would like to put on record that those pronouncements and decisions are based on the text of the the United States federal government. They're unlike the provisions of our Constitution, and I'm sure that if those scholars and judges would have decided the cases in the light of our present Constitution, the 1987 Constitution, I am not sure that they would make those pronouncements as you have recited them. And I just want to put that into the record in order to guide future scholars and future lawyers and future historians to study this matter very carefully, because while there are precedents in the United States along the lines you stated, those precedents are based on American law and not on Philippine constitutional law. Thank you. The gentle lady from Iloilo.
Thank you. We're in the process of explaining our individual votes. I've already announced to the media priorly that I was going to vote in favor of obedience to the TRO for the following grounds. Now I will try to summarize them very quickly. Under law, there is such a thing as a last clear chance doctrine. If both parties are at fault, perhaps in an automobile collision, but one party had the last clear chance to avoid the collision but did not take that chance, then he is the one who is at fault. Today, we have a TRO issued by the Supreme Court against the impeachment court. The Supreme Court is what its name implies, the Supreme Court. This, by contrast, is just the High Court of Impeachment. If we do not obey the TRO, then we are engaged in a collision course. And it is now for the Senate to avail of the last clear chance to avoid a collision, which will naturally result in a constitutional collision. That is the first argument. The second argument is this. Under the 1987 Constitution, the Supreme Court is vested with judicial power. There are two components of judicial power. One is the power to decide justiciable issues. Two, another component peculiar only to the Philippine Constitution is that the Supreme Court has power over political questions. In that manner, therefore, the 1987 Constitution has already abolished the political question doctrine, which is still observed in other democracies like ours, particularly in the United States. So, if that is the case, then the Supreme Court has a more comprehensive extent of judicial power than that possessed by the United States Supreme Court because of this constitutional provision. The case of Nixon versus United States involved a federal judge who, under American law, is authorized to be impeached by the Senate. Here we don't have that system. Therefore, the ruling in U.S. versus Nixon does not apply to the Philippine jurisdiction. It is, of course, a valid decision to be cited in American law, but not in Philippine law, because of our constitutional provision is markedly different. Third ground, the secrecy of foreign currency deposits law is a child of this Congress. We passed that law and said the secrecy of foreign currency deposits is absolute except and only except when the depositor himself gives his consent. We made that condition sole, alone, and by itself. We made that law Now are we going to break that law? Lawmakers cannot be lawbreakers. Fourth ground, the theory of checks and balances prohibits this impeachment court from claiming an exception unto itself. Under the theory of separation of powers, there are three branches of our government, as enumerated in our Constitution. There is no specific provision in the Constitution that our governmental system is divided into three branches, but you can imply it from the fact that there are three separate and successive articles in our Constitution headed with the titles, the legislative branch, the executive branch, and then the judicial branch. So by implication, we imply that our government has three branches. Now, under